Okay, good evening, everyone, and thank you. And it's a pleasure to have the opportunity to speak to you. Tonight's topic is what is a 421A apartment? And I would say that that's a somewhat of an advanced topic. Um, uh, so just keep that in mind when you're listening. I would also say that uh, in my practice as a full-time tenant attorney, it's the dealing with issues relating to 421A apartments is not a major part of my practice, but it does come up with some regularity. So I'm going to talk to you about some of the major issues that uh, tenants have come to me with who are in 421A buildings. So let's get started with the basics. So what is a 421A apartment or a 421A building? Well, the term 421A is a tax provision of the state real property tax law. And you can see some information on the screen. Uh, it's it's for new buildings, new construction. So an owner would apply for the benefit at the point right before the building is opening up for rental or for condominium sales. And what it does for the owner is it gives a tax benefit. What it does for anyone moving in, uh, if it's a rental, it may, not always, but it may provide for rent stabilization protection. Um, and that protection may be limited to a certain number of years. So what is rent stabilization? That is a broad topic, and probably most of the listeners here have heard of rent stabilization. It's a program that applies to approximately 1 million apartments in New York City, and it provides for protection from eviction and regulation of rentals, and the right to a renewal lease, etc. So generally, rent stabilization only applies to buildings built before 1974. In this case, in the 421A buildings, rent stabilization applies to new construction buildings. And by new construction, I mean, I'm not exactly sure when the program started. I meant to look that up, but I think it was around the 80s. So buildings that were built from the 80s up through the present may or may not have 421A. The other thing about 421A is that there is often, but not always, a component where an owner is required to set aside a certain percentage of the units for what it's often called affordable housing or income restricted housing, housing that is made available through a lottery system, usually NYC Connects. And those are a special category of units where the tenants must be within a certain income range when they uh, enter the unit, and they get it through a lottery system, and the rents are much lower than the rents of the other tenants. We used to often call them 80-20 buildings. It could be any variety, meaning 80% are not in the affordable category, but they might be rent stabilized. And the other 20 are the affordable. So there could be any percentage in combination, and there's a variety of benefits and structures. Really, there's no one size fits all approach in this regard. And each building should have what's something called a regulatory agreement that's filed with the city in connection with that building. And, that would be the main source of information that you or your attorney would have for figuring out exactly what benefits and programs are available in the building. If you're in an affordable or income restricted unit, you would definitely know that because you would have had to provide all that information and probably gone through a lottery system. So let's talk about the people that moved into a 421A building uh, that did not go through that process. So that would be generally a much higher rental, and the benefit is restricted in terms of time, so that and that there's no set time period for every building in New York City. In other words, sometimes it's 15 years, sometimes it's 20 years, sometimes it's longer. And when I say 15 years, I mean a specific date. It's not from the time the tenant moves in. It's from the time the building opened for rental. So let's say someone moved into a building in 2015 and the building owner began receiving 421A in 2005, and it's for a 15-year period. So then in that case, the 421A benefits would expire in 5 years. And that's important because generally speaking, the rent stabilization protection expires when the tax benefit period expires, but not always. So this isn't, so now I'm going to get to probably the most commonly asked question is, I understand that the 421A in my building is expiring. Does that mean that I'm going to lose my rent stabilization protection? And the law gives a somewhat complicated answer to that question. The general answer is yes, it does expire, but that is on the condition that at the time you first rented the apartment, the owner provided a notice. And I think that a sample of that notice is included in one of the fact sheets. It doesn't have to be exact. It doesn't have to look exactly like it looks in the fact sheet, but it has to pretty much look like that. And it has to notify you of the 421A protection and the rent stabilized status. And it has to tell you that the 421A will expire at a certain point in time. And then and only then would the landlord have the right to terminate your rent stabilization status at that point in time. So typically, if someone comes to me and they say, I've heard that the building 421A is going to be expiring, what does that mean for me? I asked them to show me all of their, their initial lease and all of their renewal leases and all the schedules, riders, notices, etc., so I can review it carefully to determine whether or not their protection will continue. Another thing that comes up is people move into a 421A building and sign a lease and pay rent, and they're not ever told by the landlord that it's a 421A building. And they find out, maybe they suspect that it's a 421A building, so they start doing some research online or with the city or with an attorney, and then find out that it's a 421A building. So in that case, the tenant, even though they were not told they were rent stabilized when they first rented the apartment, they would be rent stabilized. And the owner would have to keep them there as long as they wanted to remain under rent stabilization. So even after the 421A benefit expires. So that is pretty much how that works. So a 421A will expire, rent stabilization protection will expire, but only if the owner gave a rent stabilized lease when the tenant first moved in, and only when the owner kept giving that notice every time the lease was being renewed. And if the owner didn't do that, then the rent stabilization status would continue. So the rent stabilization status includes protection from rent overcharges and the requirement that the apartment be registered annually with the New York State Division of Housing and Community and Renewal. So you can check. One thing you can do if you're in a 421A building, or you think you are, is you can check with the DHCR and ask for a printout of your apartment's registration history. You can also go online to the DHCR website, and there's a place on there where you can look up the address of the building, and if it's stabilized because of a 421A, it should say that. There's also a 421A lookup, which is a little bit clunky and hard to use, but you can use it. Maybe you need assistance from an attorney or an advocate to use it, but it is there. And another resource is the New York City uh, HPD, Housing Preservation and Development. That's the agency of the city that keeps the records of the 421A certification, and they would be able to give you the documents through a Freedom of Information request to confirm whether or not the owner received 421A. So there are some sort of unusual situations where the 421A is canceled by the city. The owner is not in compliance for some reason. And those cases, it's not supposed to impact upon the tenants that rented apartments and moved in. The protection is supposed to continue. I will tell you a quick story about a tenant or two tenants that found a affordable apartment through NYC Housing Connect, an affordable apartment. It was marketed as such. They were given that leasing, and then moved in. And after their lease was ready to expire, before their lease was ready to expire, the owner informed the tenants that it was actually they never achieved the affordable status. They never got the tax benefit. They were going to have to move when their lease expires. So that was really terrible. I think that's a very rare thing, but it's just something to know about. And I'm not going to get a chance to talk about too many other things, but one thing that comes up with some regularity is questions about what are called surcharges. So this is what I consider to be a bad loophole in the 421A program. That say the owner has a 421A for 25 years. So as it's getting toward the end, they have the right to slap on a 2.2% surcharge to every tenant, and they can increase it annually. So then the next year will be 4.4% and so on until it reaches 19.8%. And so that's a required additional payment that the tenant has to make. And sometimes the owners choose not to charge the surcharge for some years, and then they decide that they want to charge it. And that, according to the information that I have had and found, that is okay, unfortunately. So that's why I say it's a loophole. And one other issue that has come up with some regularity is, and this is something the state, Letitia James' office, Attorney General, has looked at closely, is that an owner opens a building as if it's a condo, but they don't sell the units as if they're condos, they rent them. So it never operates as a condo, but they're getting the 421A, and they're trying to get the tax benefit and get around the rent stabilization. So there have been cases where the Attorney General or the DHCR have gone after those owners and said, you don't have a valid condo here. This is a rental. You've got to give everyone rent stabilized leases. So sometimes people are in that situation where they're told they're renting a condominium unit, but in reality, it's a false condominium or sham condominium, and the Attorney General may insist that the condominium status be revoked and that the tenants be given rent stabilized leases. And then there can be situations with overcharge. So one thing also to keep in mind is that under rent stabilization, you are entitled to the same services, which means if you were given a parking space, they can't take that away from you, or they can't, triple the rent on the parking space, or if you were given appliances, and one of them breaks, they can't take it out and insist that you buy your own appliance, that kind of thing. So that's a service that has to continue because of rent stabilization. And then I guess one final thing that I'll touch on is, what if you are in a 421A building and the 421A is expiring? Does that mean you're going to be, rent is going to be jacked up or raised to, an unaffordable level? Well, maybe not, because you may still have some protection under the new good cause eviction law, and that therefore it's not as good protection as rent stabilization, but it does give you the right to remain with relatively modest rent increases that are more than rent stabilization, but they're not as high as if it was on the open market. So if you want to figure out if your stabilization status is ending and you might be covered under good cause eviction law, you could look at how much the rent you're being charged currently. Is it more than 245% of the fair market rent? And I can explain what that means if you'd like later, or someone else. And was it a building that reopened recently? I think the cutoff date is 2009. So if the building opened prior to 2009 and your rent is below 245% of the fair market rent, you might very well be covered under good cause eviction law. So I know I've said a mouthful and I said it kind of fast. Let me see. Let me say one more thing, if I may, if you don't mind. The 421A program has been and was revised many times. And that matters to tenants because every program has different rules. Every time it was renewed, the rules changed slightly. So one of the main differences was buildings that opened, most cases around 2015, 2016, so relatively new. A lot of those cases, they had no stabilized units at all. That they had to have percentage of the affordable income restricted units, but everyone else is not protected by anything. So at least that was the general intent of the law, as I understand it to be. So it's possible it's possible that you rented 421A apartment and you have no protection, unfortunately. Although you might be covered by you wouldn't be covered by good cause eviction law either, because it was built after 2009. So anyway, okay, that was a fast presentation, but I can go into more detail and questions if you would like.
Okay. Thank you, Ronald, so much. We do have questions that came in, and you can follow along too, Ron, if you pull up the Q&A box. You see, it's like we have 10 questions so far.
Okay.
So the first question says, the 421A tax abatement expired 2 years ago. I guess they're referring to their apartment. My landlord just sent me the lease renewal and added 2.2% rider to the rent in addition to the 1.5 legal increase. Am I obligated to pay this 2.2 increase, and does he have the legal right to add it if the tax abatement has expired?
Okay, so I have to make a couple of assumptions which might be incorrect based on the information here. So you say that the 421A tax abatement expired 2 years ago. So usually that would mean that you're no longer under rent stabilization. But in this case, it sounds like you are, based on the way you describe the renewal. So this might be a case where the tenant, as you know, I talked about the notice that had to be given with the initial lease and the renewal. So this might be a case where the stabilization status is continuing after the expiration of the 421A because the landlord did not provide the notice. So let me go with that assumption. I apologize if that's incorrect. So if that's the case, this tenant is still entitled to their rent stabilized status, which means the increases are limited to the rent stabilized rates. The 2.2%, yes, I mean, that is, they do have a right to that. Although generally, if it already expired, it would have been a lot, the surcharge would be a lot more than 2.2%. It would have been 19.8% by then. So I do not know for sure how that works. But yes, the answer is unfortunately, yes, you are obligated to pay it. Yes, that's the short answer. I'm sorry to say.
I think this question was somebody from someone who came in a little bit later. They wanted to know if you can repeat how the 421A benefits rent stabilized tenants.
How the, I'm sorry,
The 421A benefits rent stabilized tenants.
are they rent stabilized tenants?
So they just said, can you repeat how this 421A benefits rent stabilized?
Oh, how it benefits them. Oh, I understand. Okay. Yes. So this is giving a form of rent stabilization, or it's giving rent stabilization to tenants in newly constructed buildings, whereas otherwise rent stabilization is mostly only available to buildings built before 1974. So that was the benefit to the tenants. That was the deal, if you want to call it that. That developers can't come to the city wanting to build a new building for rental purposes, and they apply for the tax benefits, which are very generous. And then in exchange for that, they have to keep all the units under rent stabilization for a certain period of time. So that's how it works. And then the length of time depends on the length of the benefit period, because the city just doesn't give a lump sum of money to the developer. They spread it out over the years. Well, usually it's a reduction of the taxes they have to pay, the property taxes. So, and they don't just give a lump sum in 1 year, they give it out over a period of many years. So it's during that period of time that the landlord must give tenants rent stabilized leases, and that tenants are entitled to rent stabilized status. And that period of time varies from building to building and borough to borough, and depending on when the building opened for rental. There were many combinations and permutations of the laws as they changed over the years. It could be as little as 10 years, could be as much as 25 or 30 years. And then I think there have been procedures for extending it, if the owner is interested and the city is willing. So that's the short answer.
Okay, thank you, Ron. Our attendee asked, my landlord told me I will pay this 421A tax until I move out. And is this true?
Right. The 2.2%, the multiple of 2.2%. That is true, unfortunately. That is, again, one of the loopholes, if you will, of the 421A program. I will also say that a number of people have come in or asked me that they moved into a 421A building during the COVID pandemic when the rents were lower. So the owner didn't the owner may have had the right to charge the surcharge, but they didn't because they were trying to get the apartment rented. And then the pandemic ended, the rental market picked up, and the owner goes to the tenant and says, okay, from now on, I want you to pay the surcharge. So that is something that happened to, I think, a lot of people, and people that rented an apartment around 2020, 2021, and then they were told they had to pay the surcharge. And that, as far as I could tell, that was legal, unfortunately. I want to say, when I say something is legal, I'm not trying to discourage anyone from trying to come up with some way of protesting or defending or objecting to the surcharges. It's just that I have thought about it quite a bit, and I haven't been able to think of anything. I haven't seen any court decisions on it. I have talked to other tenant rights attorneys, and no one has given me any ideas. So, I'm not saying that that's the definitive answer. I'm not trying to discourage anyone from trying to come up with a basis for challenging it. I haven't thought of anything yet. Just, I'm being honest.
Okay.
Mm.
What legal protections do tenants have if a landlord misrepresents 421A status?
So the protections are, you are entitled to rent stabilization status, whether your landlord says so or not. The rent stabilization status, it doesn't go by what the landlord tells the tenant or what the lease says. It goes by the building and the law and the apartment. So if a landlord does not tell the tenant that it's a 421A apartment, even though it is, the tenant is entitled to that rent stabilization protection. Now, they may have to fight, legally to get that protection recognized. They may have to file a complaint with the DHCR or pursue the claim in a court case, possibly, or maybe engage an attorney to write a demand letter, but so that a tenant may have to fight to get the status recognized, but it's there. It's not something that can be legally denied simply because the landlord did not acknowledge it. And I would say there's a flip side to that, which is an unfortunate reality, comes up too, which is that a landlord may tell the tenant that it's a rent stabilized apartment and give them a rent stabilized lease, etc. And then if it turns out that it's not, then the tenant is not protected. Unfortunately, at least that's been ruled on by the courts many times, unfortunately. So just so you know.
I guess to follow up with what you just said, are there known cases of landlords abusing the 421A program?
Yes, many, or quite a few. So there's this scheme that I mentioned about the condominium, claiming it's a condominium, or filing paperwork with the state and the city that it's a condominium, but not operating it as a condominium. So there's that. Another thing is, okay, this is a little complicated, but I'm going to try and it may not be explained perfectly, but okay, so when a 421A building first opens for rental, the owner generally gets to set the rent that's going to be charged to that first tenant. They cannot preserve, and then that becomes the initial legal rent. That's the technical term. And the owner cannot preserve the right to any higher rent. For example, that first tenant that moves in, they give them a lease for $2,000 a month, and it's set, but there's a clause in the lease that says the legal rent is $3,000. That's not allowed. However, that has been done many times. It was done at 125 Court Street in Brooklyn. It was done in a building in Queens that's the subject of a lawsuit that's been going on for some years. And I have seen it in my practice in other cases. So it's something that comes up, that if you get a building apartment registration for your apartment history, and it shows an initial registration that lists a rent charge that is lower than what they claim to be the legal rent, that is against the law. And that could be challenged. And sometimes people get overcharged as a result of that.
Okay, thank you, Ron. The next question is if you can, oh no, we already did that one. How is compliance with a 421A monitored and enforced?
Okay, well, it's in a number of ways, but the enforcement is not perfect, that's for sure, far from perfect. But there is the New York State Attorney General's office. Letitia James is currently the Attorney General. They have a Tenant Protection Bureau that handles enforcement of tenants' rights under the 421A. There's also the Tenant Protection Unit at the DHCR, the Division of Housing Community Renewal. And then the third thing is just individual or group advocacy by tenants or tenant representatives or tenants' attorneys. Filing lawsuits or filing complaints with the DHCR. There is not any system in place whereby every building gets scrutinized or audited every year, and the forms that get filed are checked against, the owner's records for accuracy, or anything like that. That does not exist.
Okay, we have a question, and Ron, it was asked at 7:21 because it's kind of long.
Okay.
If you don't understand how I'm wording it or reading it. Hello, I live in a building that is part of a 421A tax benefit program.
Right.
It's 80-20 building with 80% market and 20% low income. A rider was recently added.
Yeah, Roman numeral 4. Yeah.
Was recently added to my lease on page 7 and not part of my initial lease, and states that the program is set to expire June 30th, 2038. After that date, the apartment will be deregulated and the rent increases may no longer be regulated. Does this mean they could raise my rent to market rate immediately after that date? Is there anything in the pipeline in terms of regulation or laws to extend the program? If I don't have my initial lease, how can I look that up to see if this information was part of my original lease?
Okay, so well, you said at the beginning that the rider IV or Roman numeral 4 was added at page 7 and was not part of my initial lease, but then you say that you don't have your initial lease. So I guess you're saying that the way you remember it, it was not in your initial lease. So in order for the landlord to have the right to terminate your rent stabilization protection in 2038, the notice that you described would have had to have been in your initial lease and all subsequent renewals. So you are correct when you say, you may very well need to check your initial lease to confirm or to determine or find out whether or not the rider was there. And if you don't have a copy, it's not, there's no foolproof or certain way of getting a copy from the owner. Sometimes the owner will voluntarily give a copy to the tenant, but a lot of times they won't. The other thing, I guess, would be that you would file a complaint in 2038 if the owner is really does seek to terminate your stabilized status and just allege that, you know, the notice was not given. And it seems to me that the owner would then have to produce that notice. As far as like anything you could do preemptively between now and 2038, that's 13 years from now. There's probably nothing I can think of, unfortunately. You could try writing a letter to the owner now and say, I don't believe that this rider on page 7 was ever included in any of in my initial lease, and so therefore I don't think I am obligated to sign this renewal unless you want to send me some kind of proof. Otherwise, I don't think I'm obligated to sign it. You could try that. That's just an idea, strategy idea. Another thing you could try might be to file a complaint with the DHCR and say that the renewal lease offer was defective because it included a rider that was not part of my initial lease. And therefore the owner did not give me a proper lease renewal offer, and I want the agency to order the owner to give me a new offer or revise the offer to take out that, you know, objectionable rider. And so it's possible that as part of that process, the owner might back down, or it's possible that the owner might respond and say, oh, that's not true. You know, we did include the rider. Here's the initial lease. Here's a copy of it. And then you can look at it and you can decide what you want to do from there. If you think that what their owner is providing is a true copy or not a true copy. So those are just some suggestions as to how to deal with it. I see that it's over 13 years before this could happen, but I understand why you would be concerned.
Thank you. We have a question from Miss James that says,
right,
with some co-op and some rental be rent stabilized or a 428 building. My maintenance keeps going up and all I get is these other assessments every month, which is
right. Well, there can be 421A in a co-op if it was a newly constructed building, or, you know, within the last 40 years or so. So it's theoretically possible. But in that case, the 421A program does not require the co-op to restrict the maintenance increases, unfortunately. So the only protection I can think of would be whether or not you're eligible for SCREE or DREE, which maybe you could investigate that. Senior citizen rent increase exemption or disability rent increase exemption. You might get coverage under that. I mean, there's the Star Credit, which you should apply for, which at least gives you some relief. There might be some other forms of relief that I'm, not familiar with, but unfortunately, the general answer to your question is that there's no from the way you worded your question, there don't appear to be any specific rules in place that would restrict the co-op from increasing the maintenance and also imposing assessments. So I'm sorry to be the bearer of bad news in that regard, but maybe you are eligible for some benefits that might help you.
Okay, thank you. The next question comes from Lyric. I'm in a building that is subject to rent stabilization due to 421A. Our landlord nor HPD ensured proper registration with DHCR. Our landlord claimed gas and fuel, which according to Appendix A means the landlord has to provide it in the unit. Additionally, our plumbing is shared. We had a hot water heating system building-wide with washing machine and hot water in our common area bathroom, all provided by the tenants. The landlord has no hot water heater, boiler, or gas meter. To date, HPD's means of dealing with this is kicking us to DHCR, who tells us to get back to HPD. Oh, and HPD allowed our landlord to hack our common area heating. That's another story. My position is HPD should write a violation for an underlying condition and force the landlord to provide gas. How do I make this happen?
I'm sorry, I have to pause a minute because this is
Oh, it's a lot of
it's
information.
a lot of information, and yeah.
But while Ron is reading that, if anyone has questions, please do ask them. Or if you want to ask your question live, I will allow you to do that tonight. So if you want to ask Ron a question, you can raise your hand as well.
Okay, so just breaking this down, and tell me if I'm spending too much time on this one question, but I'm going to try to tackle it
That's
as
fine.
best I can. It's somewhat challenging, but I appreciate the person asking it. Okay, so I'm not exactly sure what Appendix A is, but if the landlord has claimed gas and fuel, according to Appendix A, means that maybe that's referring to rent stabilization. So if the landlord has listed gas and fuel as a service, then it has to be provided by the landlord. But it sounds like the landlord's not providing it. It sounds like the tenants, I'm not sure if the tenants installed it. I don't know, that doesn't seem possible. But maybe that's what it says a hot water heating system, building wide, washing machine, and hot water in our common area bathroom, all provided by the tenants. I'm not sure how that would be possible, but in general, I will say this: that whether this might or might not be helpful to the person asking this question, and I'm sorry if it's not helpful, but there are buildings where the owner tries to convert, where there's central heating and central hot water, which is included in the rent. In other words, the tenants don't get billed extra for it. It's included in the rent. They don't have an account with Con Ed or anyone else. It's included in the rent. So that's one situation. Then you have situations where there's individual heat and hot water, or maybe air cooling to each apartment, and the tenant pays for it. And there are some cases where the owner tries to convert from central heating and central hot water, it's maybe central air cooling, to individual apartment, and that can be done, although it's they have to go through the whole buildings department process, and then it also has to be approved by the DHCR if it's rent stabilized, and the rent has to be reduced because the tenants are now being required to pay for something that's supposed to be included in the rent. So I agree that HPD should write a violation if the building records indicate that it's shared plumbing and central heating and central hot water, and they're not doing it, I don't know if an inspector coming onto the building would do that without saying that, they have to look up building records or something or another. Maybe the buildings department would write it up. Or the other thing is maybe the tenants should get together and bring something called an HP action in housing court for the court to order it. And maybe the tenants should seek legal counsel if they can find free counsel who's able to take it on, or if they can afford. I know it can be expensive to hire a private attorney, but that would be the other option. So those are my best stabs at answering this question. I would say another option might be to reach out to the TPU, the Tenant Protection Unit at the DHCR.
Thank you. We're going to wrap it up with the last question, which is a follow-up. If the rider wasn't in my initial lease, but I signed a new lease with the rider, does that nullify the agreement of not provided? Back from the question about the
Well, I'm not sure what this means, but if you're saying that you signed an initial lease and then you moved in, and then a short while afterwards, someone came to you and they said, "Oh, we want you to sign a whole new lease because we missed, a couple of riders or something or another," and you signed it. That's a sort of a novel situation. So if it ended up in court, I'm not exactly sure how the judge would look at it, but I would certainly consider arguing to a judge that that was not valid, what the owner did, if I understand the question correctly. Because the law requires that the notice or the rider be in the initial lease. In other words, at the time the tenant moves in. And it seems to me that if you move in, you sign the lease and you move in, and then someone comes to you after that to sign new things, then that shouldn't be allowed to count, in the owner's favor, it seems to me. But I can't promise you that a judge would agree with that, but I don't know. It doesn't sound right what happened to you. I can't give you a more technical legal explanation without giving it some more thought, but that's my gut reaction.